Excellency, Mr. President, distinguished colleagues, I respectfully rise to lead the debate on a bill for an act to amend the Sheriff and Civil Process Act (CAP) X6 laws of the Federation of Nigeria 2004 to make provision for the appointment and duty of sheriffs, enforcement of judgment, electronic service of process, and execution of civil process of court in Nigeria and 4 related matters. CAP X6 law of the Federation of Nigeria 2024 to make provisions for the appointment and duties of sheriffs, enforcement of judgments, electronic service of process, and execution of civil process of court in Nigeria and for related matters. The Sheriff and Civil Process Act, a 1945 enactment, nearly 80 years old. This act was designed primarily for the appointment of sheriffs, execution of court judgments, and service and execution of civil processes to ensure that judgment creditors benefit from judicial decisions and to guarantee obedience to court orders. The objective of the bill, Mr. President and distinguished colleagues, you agree with me that legislation enacted 8 decades ago is manifestly outdated and fundamentally disconnected from present realities. Consider, for instance, that the Act still provides for a monthly allowance of 45 kobo for the subsistence of debtors' prisoners, a provision that illustrates just how far remote this law is from the economic reality of this time. More critically, the Act fails to embrace digitalization and globalization, particularly in the service and execution of civil court processes and documents. The law continues to mandate service of court processes exclusively through hard copy delivery, and personal hand service. While a court has administratively adopted practice directions that promote globalization, the principal legislation that give legal force to the execution and service of these processes remain unamended. This creates a fundamental disconnect. Our courts have evolved, but the statutory framework empowering their processes has not. This amendment will break that gap and align our legislation with the realities of the digital economy to enhance service delivery. Mr. President, distinguished colleagues, the issue of judgment enforcement, particularly against government agencies, remain deeply troubling. Government agencies have developed a reputation of non-compliance with judgments, especially monetary judgments. These stem from cumbersome and bureaucratic enforcement procedures, most notably the requirement that the consent of the Attorney General of the Federation of the State serves as a condition precedent to enforcement. The practical implication is stark. No monetary judgment can be enforced against any public body or government agency without the Attorney General's consent. Judgment creditors, without the Attorney General consent, judgment creditors find it exceedingly difficult to obtain such consent and often abandon their claims entirely. This defeats the very purpose of judicial awards, which should serve as both remedy and deterrent, as it encourages a culture of disobedience to court orders. While I acknowledge that the provision was designed to protect government agencies from potential liquidation, it has become an impediment to justice and a violation of fundamental rights. Article 8 of the Universal Declaration of Human Rights provides that everyone has the right to an effective remedy by competent national tribunals for acts violating their fundamental rights. When we make it virtually impossible to enforce judgments, we deny this right. Monetary compensation awarded by courts in civil matter represent judicial determination of rights and obligations. Government agency must align to comply with these judgments in a timely manner for the good image of government and respect for the rule of law which this administration represents. Some may argue that streamlined enforcement will adversely affect the budgetary allocation of the agencies involved. However, Mr. President, I submit that this reform will ultimately make government agencies to be more accountable and responsible in their dealing with the citizens that they are called to serve. This prospect of enforceable judgment will reduce impunity and encourage proper conduct, ultimately reducing both violation and financial burden of compensation. A judgment creditor is entitled to the benefits that accrues from a judgment obtained, and such judgment must be enforceable in accordance with the law. The systematic lack of enforcement over the years has eroded public trust and confidence in the judiciary, while emboldening officials who flagrantly abuse processes and violate the rights of Nigerian citizens. In conclusion, Mr. President and distinguished colleagues, this 1945 law neither represents nor reflects current realities. This amendment embraces digitalization, streamline enforcement procedures, and update provisions that have become absurd through the passage of time. To protect the integrity, therefore, to protect the integrity and image of the judiciary, to restore public confidence in our legal system, to promote a more responsible public service, and above all, to secure justice for our citizens. I present this amendment to this Hour Chamber, distinguished colleagues, for your kind consideration. I earnestly solicit your support for the second reading of this bill. Thank you, Mr. President.
Desiring to speak shall raise his hand in his place, and if called upon, shall rise and address his observations to the President of the Senate or the Chairman. So please take note of this order. Take note, please.
Thank you, Mr. President and my distinguished colleagues. My name is Kakashehu Lawan and I represent Borno Central Senatorial District. Mr. President, I rise to second the second reading of the bill, ably moved and eloquently delivered by our own very distinguished Senator Oluranti Idiat Adebule. Mr. President, I entirely agree with the intent and purpose of amending the Civil and Sheriff's Processes Law in Nigeria. The drafters of the 1945 Act took into cognizance the then realities of life. 1945 to date is clearly 8 decades down the line. Mr. President, for us to do justice to the Sheriffs and Civil Processes Act, we must take into cognizance the realities of modern day life by bringing justice closer to the people. So I do agree with her that doing justice to this by amending the Sheriffs and Civil Processes Law will bring justice closer to the people and make enforcement of judgments less cumbersome to litigants and court staffs alike. So, Mr. President, without much ado, I support the second reading of this bill and urge my distinguished colleagues to support the reading of this bill. I so submit, Mr. President. Thank you, sir.
Senator Adeni Ayodele.
Adeni Adebomre, Ondo Central. My distinguished colleagues, Mr. President, I rise to support the second reading of this all-important bill. As indicated in the lead debate, there are two things that strike me in this, and I think they are due for consideration. The first is the issue about consent of the Attorney General. As far as I'm concerned, I think it's a law that was done for colonial times so as to protect the British, the government of that day. But as it has turned out, this has worked adversely against judgment creditors. You have a situation in which once you get judgment against government, the way to frustrate you, having lost in court, is not to give that consent, thereby defeating the ends of justice. There are other ways by which government, like every other citizen, can protect his interest where it has a valid appeal or it is not happy with the outcome of a judgment at first instance. But what has happened here is that once they lose at the court of first instance, they frustrate your ability to realize the fruits of your judgment. The second thing is that some of the fines that are there and some of the provisions that relate to administrative costs are actually outdated. And you have a situation in which litigants now have to fund the process themselves, leading to corruption and fraud. So I stand today to support this bill for its second reading. Thank you very much, Mr. President and my colleagues.
President, distinguished senators, my name is Mohamed Tahir Monguno. I represent Borno North Senatorial District. Though two senior advocates of Nigeria have spoken in favor of this bill, and based on the tradition in the bar, I have to respectfully differ to the views and opinions of the senior advocates of Nigeria. I respect their opinion and fully adopt their argument, and wish to further add that laws are not meant to be static. Laws are supposed to be dynamic and change with the changing nature of society. As Udo Udoma JSC of blessed memory, in one of his celebrated judgments, said, and I quote, that laws are like organic documents that should change with the changing nature of society, and they are not supposed to be static. So against the dictum of Udo Udoma JSC of blessed memory, this law was a 1945 law. It doesn't envisage the advent of technology. There is no technology yet. It doesn't take into consideration years of technology, internet, and what have you. So what this bill seeks to do is to bring this law in tandem with modern realities of technology, to bring it in consonance with modern realities of technology. Two, with regard to the issue of enforcement of judgment against government agencies, that consent of Attorney General must first be obtained. I think that one is also not possible, because at the end of the day, enforcement of the judgment will be frustrated, so that at the end of the day, the rest or the subject matter of the judgment will be destroyed as a result of the frustration involved. So this arm of the amendment is also apt and germane, and I therefore support the second reading of this bill. Thank you.
Those in favor that this bill be read a second time, please say aye. Those against say nay. The ayes have it. The clerk of the Senate.